So there we go. So just to introduce myself, as you can see, my name is Ingemar Hunnings. I am a solicitor. I qualified in 1992, spent 24 years in private practice, 14 as an equity partner. I was on the board. I ran a department of 60 litigators, so I'm a civil litigator by practice. Going to just now share the screen so that you can see this is us here. So we are a management consultancy helping those within the legal services sector with all the stuff around running their business. That includes various case management systems, Leak, Clio, Action, Step, Pro, Blame. We do a lot of compliance support work around the SRA compliance, but also data protection and such like. Independent AML audits, you saw just popping up there. Consulting such as SQM, Lexel, things like this, setting up law firms. Just launched a service doing CPD in the compliance sector, and then a whole suite of support around the SQE. We're not training providers at all, but we help with confirming qualifying work experience where there is no one in the organization to do that, helping qualified lawyers get exemptions from the SQE too. And then we do some ID verification where, again, people don't have anyone who can do that for them, which may sound strange, so I will explain more in due course. Right, let's start to talk about the SQE and what that is. So I shall use now, again, some aids, which I tend to use for these. So here we go. What is the SQE? Let me explain about this. So we used to have the LPC. I actually qualified long before that even came in. The LPC was replaced by the SQE in September 2021. So it's not that new now. We're in a transition period, but we're sort of getting to the end of that transition period because I'm not even sure if people can even sit the LPC anymore. So the SQE, what is it? It's one single exam which everyone who qualifies as a solicitor has to sit. Whereas under the LPC, the training organization could set its own exams and then they would mark their own homework effectively. With the SQE, it is the SRA taking back responsibility for deciding whether someone should be licensed to practice. So it's the same standard for everyone, same exams. There are 4 elements, and I'll talk about exemptions a little bit later. Okay, so you have to have a degree or degree equivalent. So much more flexible than it used to be. It does not have to be a law degree. And you do not have to do a transition course like a GDL. That's not an SRA requirement. Okay, so degree or degree equivalent, and the candidates can check whether their exams are equivalent. And I think they use ENIC, maybe Atlantic Data, but the SRA has methods for doing that. Then you have the 2 exams, which people have to pass. They have to have a minimum of 2 years full-time equivalent qualifying work experience confirmed to the SRA by an SRA regulated solicitor or COLP. Okay, the key thing is the SRA regulates the person who is doing the confirmation of the QWE. And then we have the normal thing of proving your good character, DBS checks and things like that. Okay. I'm going to talk a little bit about the exams. Then I'm going to talk about QWE and try and demystify that a little bit. Then I'll talk about exemptions where they may apply. Okay. Then we'll move on to the Q&A. So if you have questions, please, if you could put them into the chat, and I'll then work my way through then, perhaps paraphrasing, where sometimes I find people write an essay. So I might paraphrase that to make it more of general application. Okay. Right. The exams, SQE1 and SQE2. So I'm going to use a couple of posts that I have on our website because that just makes it easier, I think, because you've got something visual to see. So the first exam is SQE1, the second exam is SQE2, fairly straightforward. The SQE1 exam is made up of 2 parts, often abbreviated to FLK1 and FLK2, functioning legal knowledge. Okay. And that's for testing your knowledge of the law. It's made up of multiple choice questions. each 180, 10 hours of exam time. It's the most appropriate answer. There's usually 4 options to the question. And timing-wise, it's quite tight. So it's a tough exam. When it first came out, there was lots of comments about, oh, a chimpanzee can pass this and such like. I think in experience, it actually has come through that this is a tough exam. The percentage of people that pass is usually about 55%. Percentage of the people who sit it. The most recent set of exam results, it was a lower percentage. The SRA was explaining recently that it depends upon the cohort of people who sit it as to whether you get a higher or lower number of people who pass. Okay. And as a qualified lawyer, I don't mind if the exam is hard because I want the standard to be high as well. Now, these exams can be sat in the Pearson VUE centres. That's where you go for sitting your theory driving test in the UK. But these Pearson VUE centres are also scattered around the world as well, so people can sit these exams in other places around the world. You can see on screen the areas of law which are covered. So that's the SQE1 exam. Now, you cannot apply to sit the SQE2 until you have passed the SQE1. Okay. And I think you've got 3 strikes and then you have to sit the whole lot again. So if you pass FLK1, but you didn't pass FLK2, you can then go and sit just the FLK2, but 3 strikes, and then you have to start again effectively. I'm not going to go into that in too much detail. And so the SQE1, there we go. SQE2 then is quite different. People sometimes equate it to the LPC. It's not. The SQE2 is the SRA having a look at the candidate, or the aspiring solicitor as they're called now, as if they were newly qualified, to see if they were a safe pair of hands, whereas the LPC was seeing whether they were good enough to start their training. Okay, quite a different standard. There are 16 oral and written tests, 14 hours of exam time. There are 4 oral. So, for example, one of those, they put you in a court-type environment with a judge who interrupts you, with a client who doesn't cooperate, that sort of thing. Now, with the SQE2, you can sit the written parts through the Pearson VUE centres, but still you have to travel to England and Wales for sitting the oral parts. I think they're sat in Cardiff, Manchester, and London the last time I looked. And they're testing in the SQE2 not just your knowledge, but also your soft skills. Okay, they want to see not only do you know the stuff, but can you operate as an effective solicitor? Okay, so that's the exams, and obviously people can, they have organizations who have established themselves as providing training for these. Okay. Now, QWE. Let me start to talk about QWE because it's much misunderstood. Qualifying work experience. So qualifying work experience, it is not the same as the old training contract. Under the training contract, you registered with the SRA and they would then effectively license you to be able to take people through a training contract. Qualifying work experience is very different. Because the SRA has taken over responsibility for checking you through the exams, then this is quite different. Qualifying work experience, you're supposed to have as a candidate or an aspiring solicitor, a minimum of 2 years full-time equivalent qualifying experience. Now, this should give you the opportunity to acquire certain soft skills, which are the things that make you effective as a solicitor. And effectively, my opinion is that the QWE is preparation for the SQE2 exam, because those soft skills are what the SRA are looking out for them exhibiting in the exam. And the SRA has tried to be as non-restrictive with regard to this as possible, because they want to make sure that they're not restricting people coming into the profession in the way that the training contracts did. Frankly, the training contracts gave the law firms all the power and control, and I know some people sadly abuse that, keeping people as paralegals, dangling the possibility of them having a training contract for years and years. Now, QWE puts the power in the hands of the aspiring solicitor. Sorry, but they can acquire their qualifying work experience. Now, what is qualifying work experience? It is the provision of legal services, and then it references to the Legal Services Act. Okay, so in my view, it's got to be provided to someone. And it is a question of what is legal services. Okay. It needs to be a minimum of 2 years full-time equivalent. What is full-time? The SRA hasn't clearly defined that, but there is somewhere, if you dig far enough through a process within the SRA, I found that they say it's at least 32 hours a week on average. Okay. So the provision of legal services within a law firm, that should be pretty straightforward. But the idea is the SRA has said this is something which we want to make more accessible. So I tend not to work with law firms because they already have solicitors who can do the confirmation, but with the other 30% of people who go through the system who are not in law firms. So I work a lot with people working in-house, more than half of those overseas, but I've worked with people in the Royal Courts of Bahrain, in the White House, in the UN, in charities, in banks, in insurance companies, where actually there's a lot of legal work being done. And some of the work is a very, very high standard, multi-jurisdictional stuff that I would expect a 5 or 6 year PQE corporate lawyer would be scared to touch. But this is the way the SRA has allowed the market, in a sense, to determine how our legal services being delivered. And it actually is allowing the SRA and English law to reach far beyond where it was before. English law is the law of, English and Welsh law is the law of international commerce. And so you'll find if you're working with people in Dubai, Singapore, Hong Kong, what law are they using? Not the law of the USA, because actually that's restricted down to state by state. So it's English law, which is the law of commerce. So very, very interesting to find all the different ways that people are providing legal services. What this means is that the aspiring solicitor can acquire that qualifying work experience outside of the law firm. And you may find people coming to you who already have their 24 months minimum requirement confirmed to the SRA. Or they may have some of it and they come to you part the way through saying, oh, well, I've been doing this work as a paralegal. It is a provision of legal services. Please, could you now confirm it to the SRA? The SRA has been adamant. They've done courses at the Compliance Colp & Coffer Conference in Birmingham, where they've been saying the QWE should be confirmed unless the solicitor has a good reason which they can justify to the SRA as to why they should not confirm it. Okay? Their attitude is very much, this should be confirmed to allow the candidate to proceed through to the exams and qualification. Very, very, very different from the training contract, okay, where the law firm had responsibility for signing off this person as fit to practice. That doesn't reside with you. You don't have that responsibility. It's the SRA's. And you may have guessed from what I was saying, the QWE can be acquired in one practice area. It doesn't have to be strung across 4 different practice areas, which allows, let's say, someone who's working in-house in a company in Dubai, where they're doing principally, let's say, contract law or employment law, to just carry on in that area and qualify. Why should they be forced, as was the case, to give up their career, move their family to the UK to go and do a seat in criminal and a seat in family, when all they want to do is carry on with their career in the company in Dubai? So the SRA has recognized the reality of the situation and facilitated that. I talk quite a lot about QWE. I'm sure there'll be questions about that as well, so I'll come back to that. The process, by the way, for confirming QWE is very simple. The candidate will go to the SRA website with your permission, put in your SRA number. That will prompt the website to ask you, they'll send you an email to confirm. You follow the link, you click on a button, and it's confirmed. The candidate, the aspiring solicitor, gets an email back saying it's been confirmed. It's that simple. The SRA is relying upon the good character of the solicitor or colp for doing that. I want to talk about exemptions. So from what can you get exemptions? So the SQE1 exam, can you get an exemption from that? In reality, the only way that someone will get an exemption from the SQE1 is if they have sat and passed the LPC and they effectively trade it in. The SRA does not like using that terminology, but it means, it's what everyone understands. You say, right, I've got my LPC. Can I get my exemption from the SQE1? I've not heard of anyone who's had that refused. But they don't like to give you exemption from both exams. Okay. So you do have a choice. Only those people who are qualified already as a lawyer in any jurisdiction. So I'm phrasing that carefully because you could be qualified as a barrister in England and Wales and apply for an exemption from the SQE2, just the same as a foreign qualified lawyer. Okay. So only those people who are already qualified as a lawyer can apply for an exemption from the SQE2. You can apply for that exemption before you sit the SQE1, not a problem. There's a form which you would fill in. There are different requirements depending upon the jurisdiction. So the SRA has had to do a lot of comparative research between the different qualifications as lawyers across the globe. Quite fascinating. And I have been dragged screaming and kicking into helping people with that. Some countries like Scotland or Brazil, to take two, have been granted an agreed exemption because of the equivalence of the level. Remember, these people have had to sit and pass, or will have to sit and pass the SQE1 to test their knowledge. The SQE2 being how equivalent the practice rights and such like are. So if they don't have the full practice rights or equivalence that a solicitor would have, then there's a little bit more that they have to do. So I won't go into the technicalities of that particularly at the moment. Exemption from the QWE. Okay, so that is possible. The QWE requirement you could be exempted from. And it gets a little technical here. If you have traded in your LPC to get an exemption from the SQE1, then even if you're a foreign qualified lawyer, you will not be exempted from the QWE requirement. I got this clarified by the SRA quite recently, because you're effectively hopping across from one system sort of qualification to another. They would then require that person to still get their QWE confirmed. However, if you were a foreign qualified lawyer and you're just sitting and passing the SQE1, asking for exemption from the SQE2 or not, you would be automatically exempted from the QWE requirement. Okay. There is the ability to supply a dossier of paperwork to ask for the SRA to regard that as equivalent to a training period or period of recognized training. I don't really get involved in that, and that sounds like a lot of hard work to me. But in general, it is if you are a if you're a qualified lawyer, you can get exemption from the QWE requirement, qualifying work experience requirement, unless instead you have got an LPC pass, which you're trading in summary. So I was just going to say a little bit about apprenticeships. Apprenticeships, brilliant. The SRA carefully designed the SQE to work with that. And it was that if you were a graduate, you could also join the apprenticeship scheme. That is really coming to an end from the graduate joining stage. If you're joining from school leaver, it's still there. But if you're a graduate, I think the last intake may have been received already. I'm not sure. My understanding is that a graduate apprentice, just joining it as a graduate, is really disappearing. But if you're going to be coming in as a school leaver, brilliant, go for it. The SQE works with that. And the feedback from the SRA is that the apprentices outperform everyone else. They do better in the exams than anyone else. So again, they're hoping again to open up and make it a more broad intake than it has been in recent years. I'm old enough to remember and know people who joined through just working in a law firm and then gradually taking exams. And it's sort of turning the full circle with regard to that. Okay, that is more or less what I wanted to say to try and explain how the system works. Can you think of anything that I've missed out there, Lorna?
No, that's a great introductory overview. I know that we've got some questions that prompted us to have this event, and actually the questions and answers were the bit that people felt most that they needed, weren't they? So I've got those questions that we can sort of discuss, and they might be things that perhaps people haven't even thought of yet, or that people think, oh yeah, that's exactly what I want to know, but hadn't thought to put it in the chat. So Everybody, please do put questions in the chat, any questions at all, to make use of the fontable knowledge on SQE that is Ingemar. In the meantime, John will also put into the chat some useful links and information for everybody. And I have to say, I think we're an even split here today of people from training providers and from employers. So lots of different perspectives and lots of different things that people might need to get from today. So I will, while we're waiting for people to put their questions into the chat, I'll go back to the questions that we were given during chats with employers and emails, Ingmar, if that's okay. So I will work my way through those. And the first one is, can all qualifying work experience be in one specialist practice area?
Well, the simple answer to that is yes, it can. And I think the SRA were looking at the reality of the situation. For example, people working in-house, they already have their career, they're already working in a particular area and have no intention of going to practice in another area. So the SRA has said, look, the qualifying work experience, its purpose is for you to pick up the soft skills, the knowledge you're learning in the exams, and you're being tested in the exams on those as well. So they're not going to force you to effectively take a seat in another area which that organization won't provide. So if you take an in-house situation, they probably won't do litigation. They'll probably outsource that to an external firm when it turns litigious. So they're saying, look, the purpose of this is for you to acquire the soft skills, at least some of them, and there are 18 of them. So no, there's no requirement for someone to really do any more than one practice area. As long as they're providing legal services, then they're meeting the requirement.
Okay, thank you. And another question we had from an employer was, can employers still use training contracts? So can they offer what they have to offer as a training contract, and can they still run that period of experience in the same sort of format if they want to?
Certainly, under the SQE, the phrase training contract doesn't actually have any meaning, whereas under the LPC, it had a particular technical meaning. So it then is largely a question of employment law or contract between themselves and the employee. How they want to structure it is entirely up to them. And so they can take that and structure it as they will, rather than being told how to do it by the SRA, and build it around their own practice. Looking at the aspiring solicitor and saying, okay, in order to get the best out of you, if we want to employ you, we'll do this, this, and this, and this. So it gives you the flexibility, but it does become a question of employment law overlaid by the process the SRA has given you. So be aware that although you may take this person through, let's say, 4 seats within your firm, that person may have, and that might be over a 2-year period to take a very traditional approach, that person may already have 12 months of QWE acquired, let's say, through working with the Citizens Advice, and that's already confirmed. Or they did some work whilst they were at university, or what have you. And so it may be that part of the way through that 2-year period, they have acquired all of their QWE. Now, bear in mind, the SRA is not keen for you to say, oh, but we won't confirm your qualifying work experience, which is the provision of legal services, because you haven't finished our 2-year process. That is running counter to what your regulator says, assuming you're regulated by the SRA. So there's this discussion that needs to take place with regard to all of this, but it's employment law. So contracted employment is good to be open, I would say, when you're taking someone on. They may well, and you may see this, be saying, the work I'm doing seems to me that I will be doing qualifying work experience. Will you be willing to confirm that for me? I'm sure many of you have had that conversation. And that may determine whether they want to accept your offer of employment. So, as I said, turning this back, it's about employment law overlaid with what the SRA says about how people qualify.
Thank you. And, if anybody thinks they've got a follow on from that, please do put it into the chat. But Sort of leads on, I think, to the next question that we had from an employer, which was, what official checks are there on the QWE? So, you made it sound forward, and you said specifically what they're aiming to do is take away lots of the pressure and simplify things. But potentially, what checks does an employer need to be prepared for from the SRA?
As far as I know, the SRA really hasn't done a lot of spot checking. So I don't know whether they will in the future. And where I am acting as an external confirming solicitor, I'm very careful to make sure I'm very methodical and I keep evidence of that. But it is nowhere near what you had to do under the old LPC training contract. So if I was back as a partner in a law firm, I would still want to see evidence that the person was thinking about the skills they want to pick up. I'll share this here to show you what I use when I'm doing the QWE confirmations. I've taken the SRA form and I've modified it slightly. You can see get the QWE in up to 4 placements, no more than that. This table, I've added some letters and numbers, but it's the same stuff here. These are the competencies. And you can see that you can use this as a personal development plan. And that might be a good idea. But we're, again, drifting into employment law good practice, where maybe you have a quarterly or a monthly meeting with your aspiring solicitor to see whether they're getting the experience that they, would or could get. But if getting into this area of good practice as an employer, getting the most from your employee, the SRA is not going to dictate, and they're not going to say, can we see your training record? Because they really have stripped away all of the paraphernalia that you had before. It is very much a question of doing the best that you feel ethically you should be doing for your employee during this process so that they can acquire the competencies. Yeah, I would say don't over-engineer it. Unless you feel there's a good reason to, but the SRA not forcing you to.
Okay. That's really helpful. It looks like a useful form for clarity as well. Because sometimes there's just as much chaos and confusion caused by an open door of, we'll do whatever you would like to, as there is by being very prescriptive, isn't there, So to have some sort of review in place is a good idea. And I know some of our colleagues I hear from training providers who, offer apprenticeships. And so apprentices, as you said earlier, are probably getting some of that structure from us and getting some of that sort of the documentation, the review opportunities, the reflections, it's encouraged, in their coaching, in their teaching, etc. But perhaps outside the apprenticeships, it is a bit more of a free-for-all, which could leave some employers and some trainee solicitors feeling a little bit lost. So I think a framework of structure is a good idea, isn't it?
I would thoroughly agree with that. But it's just good business practice to have these quarterly, or we used to do monthly meetings. I used to say to my staff, well, look, this is a space for you to discuss things without any pressure. And then we could move it later on, perhaps to KPIs and things like this. But it meant that when the annual appraisal came, there was no surprise. If there was a surprise, there was a failing on both our parts in not sharing. So a light touch on the tiller rather than a yanking the ship round in another direction.
Absolutely. And then finally, on what we were sort of given up front, not really a question, just a reflection with you might have some thoughts on, but also some as the attendees might have thoughts on. So one of the biggest concerns that employers discuss with us here at Brightlink when we talk to them about SQE and qualifying work experience is they express a bit of concern about these 4 different opportunities to gather the QWE from different placements. And sometimes they will feel that somebody will come to them already partway through. And of course, this is what trainees needed and what the SRA wanted to facilitate, that people could have a portfolio of experience and they could be more flexible. But for some employers, it's a bit of a concern that they feel as though they are endorsing qualifying work experience that they haven't really seen they're picking up halfway through. They're saying, we can confirm and sign to say we've seen these bits, but they don't always feel like the qualifying work experience that's happened before is necessarily an appropriate standard for somebody who they would want to say proudly, this is our new solicitor. And they have sometimes a bit of anxiety about those sort of standards, their internal standards, and also some concerns sometimes about whether they have a job to offer. You know, they'll say, we've got this brilliant paralegal who's working with us. We have X number of paralegal jobs to offer every year. We have X number of solicitor jobs. Our solicitor jobs are completely full. We don't have that opportunity to give somebody, but all of a sudden, here they are, fully qualified. Now what do we do? So I think those are a couple of practical concerns. The first sort of more about qualifying work experience that's happened in different places. The second about how easy it is now to gain your qualifying work experience. Do you have any thoughts on that for reassurance for employers in general?
Very good points. So if I take the first one, so should you confirm someone else's QWE effectively? So someone comes to you, can you confirm this year at QWE? The answer is you should only confirm the QWE which was acquired while you're employing them. You can't comment on someone else's unless you act as an external confirming solicitor where there are additional requirements from the SRA. So I would say if you're working in a law firm, someone comes to you, oh, I was at Blogs & Co. beforehand, can you confirm their QWE? That's a different kettle of fish. And unless you want to get involved with being an external confirming solicitor, I'd leave that alone. You should only talk about the QWE which has been acquired in your firm. And then it's that very simple process which I've talked about. So you'd certainly be within your rights to say to an aspiring solicitor, I haven't seen the QWE you did at Blogs & Co. down the road. Go and speak to them, or at the Citizen's Advice, or wherever it was. You know, the SRA is only expecting you to confirm the QWE acquired, under your supervision. And it may be in your firm that you have a solicitor who you have nominated as the confirming solicitor. They may then need to take feedback from the supervisor and check the work and such like. Presumably they are becoming specialist in that, and I'm happy to do a one-to-one with that person if you want to nominate someone to talk through that process so that they know what they're doing, because I do that all the time as a completely external confirming solicitor. So confirming someone else's QWE, that's what I would say with that. Don't stress about it. If it's someone else, another firm, leave it alone, unless you specifically want to get into doing that. So any obligation to take people on after they qualify, that's a question of employment law, just the same as it was under the LPC when you did a training contract. As far as I know, there's no obligation to take someone on. Yes, you may have invested lots of time and effort in them, but that's a commercial decision, employment law decision. If someone qualifies, then you decide whether you take them on or not. And you use the same parameters you would always use for that. Do they fit? Is the quality good enough and such like? It may be different because they may bring other attributes. They may have done a degree in let's say, a STEM subject, which you think, what? But it gives you a different approach, which before wouldn't have been available. Everyone just did a law degree and that was it. But you have no obligation to take them on. Whether the quality will be the same, time will tell. I'm not a training provider, so I'm in somewhat of a difficult position to answer that. If people ask me, I would say speak to the recruitment agents to see whether, when I'm talking to an aspiring solicitor, what the market is like. The market will change, the market will adjust, the market will be different. I have said to the SRA, I think that in 10, 15 years, you may find that you have more people who are registered as solicitors with you from outside the UK than inside the UK, because I see a huge number of people cross-qualifying. Interesting.
Yeah, absolutely. I think we've partially answered Vanessa's question in the chat. Vanessa asked, can you only sign off at QWE if undertaken in your firm? So you've just explained that it would be your advice strongly to only do that. That's what you've actually seen, isn't it? That's what you can endorse. And then Vanessa says, what if they were a paralegal previously and asked you to sign that off? I guess that advice stands then. If it was somewhere else, let them sign it off. This is your part of your work with them. You sign this off. But if they were a paralegal in your organization and then switching to become a trainee solicitor, then yes, you would be signing that off, wouldn't you? It doesn't matter what their job title is, really, does it? It's about the work that they're doing.
Yeah. So if someone has worked as a paralegal in your firm and then moved on to your more official training program, that's all internal stuff. The SRA is completely not interested in what the description of the job is called. It's the nature of the work, which is really good because they're looking through whatever, games people might play with putting names on people. If they've been a paralegal, then they have been providing legal services. That is QWE. Whether you then put them on the training contract, because that's what you want to call that particular form of employment, that still presumably is QWE as well. So as far as the SRA is concerned, it sees past all of that just to the nature of the work that's being done. Is it the provision of legal services? Yes, it's QWE. No, it's not. And then it's a common sense approach. So I tend to run a rule of thumb that if someone is doing 80% QWE, that's close enough. If it's 50%, then that's going to take 4 years to get 2 years full-time equivalent. They do 50% qualifying work experience, the provision of legal services, or they're spending 50% of their time managing and 50% of their time delivering legal services. That could be a situation where someone is doing that. Let's say an HR department, they're managing the team and 50% of the time they're actually delivering legal services to the company as the HR manager. So, yeah, but they may be able to reach back in time over 10 years while they've been doing that. So they've got plenty of QWE.
Yes, and we see that often actually where people have sort of 50-50 in exactly that way because they're running a department or an organization where they don't have a full sort of caseload, and it's taking them a little bit, despite huge amounts of experience, it's taking them a little bit longer, So yes, I can see Lindsay has put into the chat any tips for those of us taking the SQE one in the coming months. Do you mean a course or the exam itself? Or preparation for such a large exam? They are massive exams. They have huge breadth and depth. So I don't know that we'd have time now to give you all our tips. I'm sure between us we've got lots, and I imagine that lots of people who are here can pop their favorite or their key tip into the chat for sure. And you're very welcome to give us a ring or send us an email here at Brightlink. John will share the details so that you can get in touch and ask us. Brightlink next SQE1 preparation course begins in February 2026. We only run one a year, and we keep our numbers very small indeed to make sure that we can give everybody lots of attention, not just for the content for FLK 1 and 2, but also for those study skills, exam skills, that sort of support. And again, John will either put into the chat or send in the follow-up email links for how you can get onto our SQE1 prep course if you would like to. But even if you've prepped somewhere else, do drop us an email. We'd love to hear from you. And if there's anything we can tell you to help, we'd be happy to. Vanessa, Lindsay's question. Yeah, absolutely. So yeah, people are starting to put their tips in there for you, Lindsay. Hopefully that's helpful. And as I say, John will put contact details in as well so that you can reach us if you need to. Are there any other questions for Ingemar? And also, while you're thinking of that, our data law colleagues who are in the room with us today. So we partner with data law to offer SQE apprenticeships, solicitors apprenticeships, graduate solicitors apprenticeships specifically. If you still have any places left and you would like to speak to people who are interested, please do feel free, data law team, to pop into the chat and let people know how they can contact you so that you can share what we're offering there. Last cohorts in November and December, Catherine, data law says. So yes, if you want to put phone number or link for the way that people can reach you who are interested in getting their apprentices onto those programs, that obviously is in England, because unfortunately in Wales we only have level 3 and 5 apprenticeships. But if you do want to talk about those apprenticeships, again, myself, John, and Kaylee can help you with that. That's no problem. Who else? Vanessa, not question, comment. So Vanessa says, difficult to get your head around not signing off as fit to practice, but simply signing off that they have undertaken qualifying work experience rather than the quality of that. What are your thoughts on that, Ingmar?
It is a huge cultural change, but I suppose if you're paying your dues to the SRA, then in a sense, they're taking back that responsibility. They license to practice and they pick up the pieces if people fall foul of it. So there's a logic to that. It also gives a bit more uniformity, because although some people were very diligent about whether that someone was fit to practice and signing them off, other firms were not so. And so you had a variety of quality coming into the profession. And so there's an argument for saying, yes, quality assurance through the SRA, through the exams, because everyone goes through the same route. So, I mean, in a sense, I can say whatever I want. I have no influence over what's going on.
Yeah, I don't know whether other employers here as well feel the same way, that, but of course it is a huge paradigm shift, isn't it? And it was what was intended by the SRE with this new method, isn't it? That it would become more accessible, more straightforward. But as an employer with quality standards, I think that's exactly what you were saying earlier, isn't it, Ingemar, about having those frameworks, the reviews, etc., about being really clear about what your expectations are. And I guess that's how to address that, really.
Indeed. I mean, in the end, you can't have a completely controlled marketplace. The marketplace is so different now with the internet and people working remotely as well. And I've spoken with people who, aspiring solicitors, who said, right, I've done 6 months. I was speaking to one who was with a very well-known Magic Circle firm in Morocco. I've confirmed a period of QWE. He's moving to another Magic Circle firm in Morocco, and purely because he wants to get different experience. So he's taking control of that himself, because he knew obviously the offices for those Magic Circle firms in Morocco are fairly small, but he's taking ownership of that and saying, no, I now want to go and get a job somewhere else to get a different type of experience. And I've seen that with people working in-house as well. They say, right, I've been doing this for a bit. Now I want to go to another company to get a different type of experience. So I become more rounded, because the firm I was at doesn't have that breadth of experience. So you could say high street, oh, well, you can take 4 seats in there. Okay, but I want to get an experience in-house. I want to then work in let's say, an employment boutique specialist that's doing high-end work. So people can do that, whereas before they couldn't. They were tied into a training contract with the organization, and that was it. Quite different, huge paradigm shift. It could be that it's worse, or it could be that's better. It's just different.
Absolutely. And I know that, Vanessa, you are working in-house, aren't you, really? So a challenge, some of those challenges are shared with law firms, and some of them have a bit of an extra dimension, as Ingemar just said as well. So Vanessa asked, do you find that firms tend to fund SQE1 and or SQE2? So from our perspective as a training provider, a combination, self-funders, people who fund 50-50 with their employers, and employers who fund everything, a real mix. There is no definitive on that. And also sort of graduated options, where some employers will say, we'd like you to start out yourself. When we see your commitment to the study and your progress, then we will step in and be willing to start to fund some things. So all different sorts of approaches. Obviously, as our colleagues here from Data Law are offering, I think it's up to 95, if any of them are still here, they'll correct me, up to 95% funded in England for their apprenticeships. But here in Wales, as I say, we have the level 3, the level 5, which obviously are SILEX based. We hope the level 6 as soon as the Venath elections go through. So that will be the pathway here. We will be offering SILEX apprenticeships in England very soon at level 6 and 7. And with the funding withdrawal for large swathes of the sector, the only funded, fully funded, mostly funded route to practice is going to be the SILEX level 6 apprenticeship. So lots of things changing there, lots of things happening there. Anybody who wants to talk to us, you're very welcome. So it's a mix. Sorry, Vanessa, there's no definitive answer on that. It's a real mix and can depend. And as Ingemar was saying, can be really closely linked as well to things like probationary review, annual reviews, and a bit of a collaboration between you and learners in terms of payment and other kinds of support as well. Yeah, midway reviews. Yeah, good ideas. Anything that you'd want to add on that, Ingemar, about?
No, I suppose because I'm working in that 30% who don't go through law firms, the majority I come across are self-funding. Um, yeah, I'm amazed at the tenacity of the people who are just working their way through, having done a degree, now going through all of this as well to qualify. It's really humbling. And sometimes from very poor countries, in Africa or wherever, and they're finding a way to get the money together to qualify.
That's amazing. I spoke with somebody on the telephone earlier today who is switching from SQE to SILEX because she completed her SQE1. So that in itself is a massive achievement, isn't it? It was successful. And then failed the SQE2 by 1%. And obviously have to now resit all 16 assessments because one of them failed by 1%. So she was devastated and said, I can't do it again. I need to do something a bit different. So that was literally just before we came on the call. I spent quite a bit of time on the phone talking her through that. So yeah, it's brutal in lots of ways, isn't it? Yeah.
It always has been, the exams are the exams, I did the Law Society finals and if you failed, you failed, you had to sit again.
Yes, absolutely. Yeah, same. I did the LPC for my qualifications. It has always been for, I remember that first day going into induction and the message was you can have half a day off on Christmas Day. And if you're on top of your stuff, you can have half a day off on your birthday. That's it. The rest of the time, you're studying, you're working. That's it. End of, and that hasn't changed hugely, I don't think, Any other questions for Ingemar or for myself before we finish? If not, it's been lovely to have you join us. John, as he said, is going to follow up with the recording and more information as well. If anybody wants to stay on, myself, Ingemar and John are going to stay for another 5-10 minutes. So if there's anything you specifically want to be able to ask us, please do stay in and ask. But thanks, Vanessa. But it's been lovely to see you and have a good day for the rest of it.